All rise. Your Court of Appeals Division 1 is now in session.
Please be seated. We are here today in our case 1C JV23-0057 in ready to move parental rights to NR and NR. Each side will have 20 minutes to present their argument. Upon it, you may save as much time as you want for rebuttal, but you're in charge of your time. This however clock at the podium so you can keep track of that. We are recording the argument both in audio and video. The argument will come up in YouTube in a day or two, so you can see how well that you did. When it's your turn, please identify yourself and your client so that when we review the argument, we can keep everybody straight. We've read the briefs and copies of the case, so we're fully familiar with the facts of the law. So when you begin your argument, just start out with what you would like to talk with us about. Thank you. Counsel, you may begin.
Thank you so much. First, I'd like to express my appreciation both to the court for the oral argument and also to my colleagues. We don't probably say this nearly as much as we should, but the level of professionalism has been outstanding in this case, both in terms of correspondence, communication, and the brief writing, and it's appreciated. So I wanted to set the record straight on that. I have only really 4 points that I had hoped to emphasize for the oral argument on behalf of my client. My name is Thomas Alongi, and I represent the maternal grandmother and the applicant for the severance. She goes by Christina Messina. She might have gone by Dickerson in some of the paperwork. And my co-counsel on the brief, Elizabeth Alongi, is also here today, seated to my left. So the 4 things, in addition to answer any questions you might have for me, I only want to talk about 4 things, or to highlight, if you will, because they seem to be recurring themes in the briefs. And one was this idea of this guardianship, and whether it was enough to note that if a problem developed further down the road, we could always go back and do a dependency or a Title VIII guardianship. I don't fault either parent for making the argument, but there are problems with that suggestion. First of all, to do it, if something were to go wrong, or if there was a need to go back and revisit the severance, to do a Title VIII guardianship, that's governed by ARS 8-871, and there are requirements that have to be shown to get that petition off the ground. And one of the things, ironically, that an applicant for that sort of guardianship would have to show is that the likelihood of adoption is remote, or that severance would not serve the child, which would seem to be the antithesis of what was going on in this case, which is that adoption was very much an alternative. It's simply that this court chose not to do it. Not this court, the trial court. So to the extent that the argument from the parents is that, hey, all is well, we have this voluntary Title 14 guardianship, and if things go wrong down the road, we can always go back to juvenile court. Aside from all the baggage that comes with that process that I mentioned in my brief, there are some statutory barriers that I think would cut against the situation that we have in this case. Point number two.
Are you saying that you were going to be able to meet those requirements down the road?
I think if I were to go back, if this appeal gets denied and we go back, and there's some cause, some reason to go in and apply for the Title VIII dependency. Let's say one of the parents says, I'm revoking this voluntary guardianship, I want to assert my rights. We would have to go to juvenile court or give up the child. So if we go into juvenile court, I am sure that my client, if I'm standing next to her in front of the juvenile court, I'm sure we could prove that there are reasons to continue the dependency. But my client would have to avow, among other things, that adoption is a remote likelihood, when her very argument at the last trial was that adoption is the way to go and that she should be the one to do it. So it's not a question of me proving it. I would have to...
She would only have to make that argument if she were seeking a permanent guardianship as opposed to trying to seek termination. Isn't that right?
I think if she's going to go back and apply for termination, then I think she would make the argument she made once before. But to get to that, the vehicle to get to that severance petition, there would have to be some sort of Title VIII proceeding to get to that moment, whether it's a dependency or a Title VIII guardianship.
She could also go to family court, right, and get get third-party rights.
She could do a petition under Section 409, but the problem with that is the same lack of permanency that she's been handed here. There's no doubt that the family court could make an order recognizing her intervention as a party, grant third-party custody, and even suspend temporarily the rights of the parent. But if the don't like the word lodestar because it's used way too much in the legal profession, but if the lodestar of all of this is permanency for the child, to have some sort of resolution to not leave the children languishing in the home with their grandmother, wondering, does this ever end? Does it stay the status quo? I'm not sure a family court petition does a whole lot more than what they have right now. The only benefit, to be fair to this court and what you just asked me, is at least you would have a court order. The parents could not just walk in and put the stop to the voluntary guardianship, but you would still have impermanency. There would be the expectation in family court that you don't have with a severance, which is periodic review, that a parent could come in and do a modification to cite a substantial change of circumstances. And our view and the argument below was that both mother and father had run the gamut in terms of the idea of a future modification, and that our client should not be forced to do an indefinite, in perpetuity guardianship that could be erased at any point.
Counsel, go ahead. I just want to make sure that I'm on the same page with you about what we understand the Superior Court to have found. So with regard to the abandonment ground, what is your understanding of what the court concluded? Clearly the court concluded that the ground was not met, but what was the basis of the court's ruling? Was it that the facts did not amount to abandonment, or that the fact of the guardianship was enough to defeat, all on its own was enough to defeat abandonment?
The answer comes in two parts. First, looking at the court's judgment, the trial court's judgment, it's difficult to see where the court cited a fact that would back up the idea that there was not abandonment. And that's kind of the irony, the perplexity of this judgment, that the findings of fact are really good. You go through page after page, and she cites the fact that mother had gone off to treatment for extended periods, that she wasn't even there for the two hearings where this whole thing was decided. It presented this kind of surreal appearance where you had all these findings that made you think, okay, the conclusion is going to be a severance, and then really the only thing she says at the end is that because there's this guardianship, all is well.
Well, the court also found that she had seen the child 4 times in the last 6 months and had spent seen them on Christmas. So there was some evidence of contact that the mother still had with the children.
Evidence of contact for sure, but I'll put it this way, my argument would be a lot different, and we might not be standing here today if the trial court had said, here are the findings, and because these are the findings, I find that there is insufficient evidence of abandonment because mother had this contact, this communication, this presence in the home. But the court didn't do that. The court noted in passing, yes, there are these aberrations, if you will, but the thrust of the factual findings was that she was largely a no-show. And there's nothing in the court's analysis at the end to suggest that these aberrant contacts were what convinced her not to do this.
One of the facts that I think we had testimony on in the record was mother's intent to permanently reside in Florida. Can you confirm for me, was there any clarifying testimony as to whether mother's intent was to permanently reside there but eventually bring the children, or just was the record silent on that point?
It was silent. A fair question and a good one. I think mother's absence from the trial made it difficult to know. And if I remember right, I think when my client testified, she mentioned that there was the one treatment and then the second one, and that no one was really sure what had happened with her absence at the severance and whether that meant she was going back, had the plan to bring the children later. This is part of the challenge of every lawyer in this courtroom. Not one of us did the trial, but my recollection of the transcript is that there was no moment, to be fair to both sides, there was never a moment where anyone testified that mother did or did not have that plan.
Okay.
And I don't think that's in the judgment either. And that would have been significant.
Sure.
If that...
Taking you to the substance abuse ground with regard to mother, as I understand the presentation of what's in the record, we had your client testifying about sort of her understanding of facts on the ground in Florida, that mother had gone there for rehabilitation. Whether or not she completed that successfully, there was some evidence of post-rehabilitation criminal charges. First question, did your client ever testify about any convictions?
I don't remember testimony about convictions. In fact, I'm sure she didn't, because my recollection when I was trying to construct the statement of facts with Ms. Alonji was that in fact, I think one of the points we made in the brief was that it wasn't altogether fair for the court to criticize the grandmother for failing to produce that information when she wouldn't necessarily have had access to that information and mother wasn't there to say differently. But I think you're right. I don't think there was any evidence of the conviction, just the allegation that there were criminal charges out there that might have been connected to this issue.
Okay.
I think that's as clear as it ever got.
Okay, and was there any record evidence, whether testimony or otherwise, offered that affirmatively said mother was clean post-rehabilitation?
No. In fact, I think the only two witnesses who testified, not from hearsay, but from personal knowledge, were the grandmother herself, who testified about the condition of the home while the mother was cohabitating there, and then I think father himself testified about mother's drug use in his own testimony when illustrating the struggles that they were both having with their backgrounds.
Okay, thank you.
What do you think is the significance of the fact that mother didn't appear? Can the court draw adverse inferences from that?
I think it can. And again, I think it's important to be fair. I know that her absence by itself does not mandate a reversal. The trial court could have found, if it wanted to, information with the right testimony, whether if father had said A, B, and C instead of father saying D, E, and F, if grandmother had admitted X, Y, Z instead of 1, 2, 3, theoretically the trial court could say, hey, whether mother's here or not, this record does not justify either the first prong, which is a statutory basis, or that doesn't justify the best interest of the children. As another example, you could have had clear evidence justifying the severance, but maybe there could have been testimony from a therapist or a DCS worker, if DCS had been involved, to say, well, bad behavior or not by the parent, this child's best interests aren't served by severance. So I think you could have that if the record had justified it. Here, the problem with mother's absence is, A, she wasn't there, and that shows a continuing course of behaviors of abandonment, but it also left everyone else guessing whether she had rehabilitated, which with Judge Perkins' question, was there anything, could mother have stepped up and said, this is my game plan, 1, 2, 3, 4, 5, if you will give me that second chance? She denied herself that opportunity. I don't think the children or my client should bear the burden of what happened there.
If mother was undergoing treatment in Florida for her addiction and was unable or unwilling because of the treatment to travel back to Arizona either to attend the hearing or to otherwise parent the child, is that evidence of abandonment?
If that had been the evidence, I think it would be very difficult for me to argue fairly that her rights should have been severed as a due process matter, because in that position I assume that her trial counsel would have made that point, asked for the continuance, or simply made the argument, the fact that she is in treatment now and trying to fix things, and here are her treatment records, and she can't appear today, Your Honor, because she's in this process with the facility, then I think it makes my client look really bad to go in there and say, well, let's sever her anyway, whether she's doing well or not, because it makes it look like she's rooting for mother to suffer harm instead of doing what's best for the kids. So if that had been the evidence, I mean, I can only say that if I had been a trial lawyer, my argument would have been, let's do a continuance to see how the treatment went, and so we can see if this is really just another relapse, or do we have progress? But we didn't have that.
As far as analyzing best interests, usually is termination or adoption, or you do a termination because it's in the best interest of the child will likely be adopted. How are those factors altered when we have a guardianship where the status quo, I understand there are permanency issues, but the status quo in terms of caring properly for the child is equally served by the guardianship. So how did the trial court err in how it analyzed the best interest, and how do we look at that?
I think the straightest answer I can give there is that if we are to have a precedent, or even the idea, that a Title 14 guardianship, if it's good enough, could serve as a substitute for adoption, then I think we need to revisit the current state of Arizona law, because even the cases cited by Commissioner Dyer talked about adoption being the salutary purpose of a termination. This is why we do this. We don't want it languishing along. I think I may have made a half tongue-in-cheek but half serious argument in my own brief, which is, if we're going to start warning guardianship candidates that if you're really good at what you do, you've just undercut your own argument for adoption down the road because you're really good at what you do, I don't know if that's the kind of message we want to send to stakeholders in juvenile court, and I don't know if it's the kind of message we want to send to relatives in general. I don't want to, and I assume any lawyer would feel the same way, I don't want to be in a position where I would have to advise my client, a grandmother or an uncle, whatever, hey, do this really well, but not too well. or the argument from the court's going to be, well, things are going great, let's just keep this guardianship going. And again, that also, the rest of my answer to your question is, you're still at the whim of the biological parents, and not even that the parents would have malice, not even that they would do it to hurt anyone. The whole point of this is not that they have bad character. The point is that they, by their conduct and choices, they have removed themselves as candidates to be caretakers for the child. And at some point, you don't want a parent walking in and saying, I want to revoke this voluntary guardianship, and if you don't like it, then we can all go back to juvenile court.
Yeah. How long has this guardianship existed?
Formally, the guardianship, not long. If memory serves, and counsel will certainly correct me if I get this wrong. I think the guardianship itself was effectuated a year, maybe a year or two, it seems to me it was the preceding calendar year before the severance occurred. There was also a wrinkle where the court had to clean up the issue of father being notified of the guardianship, and I think that's even stated on the last page of the trial judgment. But the grandmother had been caring for the children since one child's near virtual birth, and since the other child, I think for 2 or 3 years, had been the only source of support. So there's a disconnect between the formality of the guardianship and how long she was, in fact, taking care of the kids.
So is part of the analysis the length of the guardianship? Had it gone on for 5 or 10 years, then there's certainly more evidence that the parents didn't intend to reassert their actual parental rights.
I think my response to that is that if the issue is going to be how long is too long of a guardianship, a voluntary Title 14 guardianship, then we're back to the same issue, because that would seem to cut against the argument that we want to have permanency planning. Look at any other aspect of juvenile court where DCS is involved. Foster parents. We don't tell foster parents, even really good ones, hey, you need to string this out 2 or 3 years because who knows, things might work out. We would never dream of doing that, because the whole focus of Title VIII with public severances is we want these kids resolved one way or the other. So unless you want to have a double standard where a private petitioner, because there's a private guardianship, they're kept along for 3, 4, 5 years, apart from the whole issue whether that's good for kids at all, because now they're going to elementary school, now middle school, now high school. Where do you draw the line? What evidence would you expect to see in terms of the quality of the guardianship or the parental indifference 4 years from now that you don't already have?
So is a guardianship antithetical then to resolving the permanency issue? So you should never have a guardianship because you run into this issue.
I think they made that argument, and my response to that is I have no issue with guardianships. They serve an important function. Parents going to be traveling internationally, might be ill, might have to go in treatment for a couple of months. There is certainly a significant role that a Title 14 guardianship can and should serve without repercussions to a parent in juvenile court. But we don't have that here. We have, in part, the absence of any kind of formality, just grandmother taking care of the kids for a stretch of time, and then we have this effort at a guardianship with no prospect of change. So I am not advocating, and I don't think it's entirely antithetical to say that a Title 14 guardianship should never be done because severance is the only way to go, because there's an important middle ground where it could really make a difference in a child's life. Our only point is that as a matter of law, it was error for the court to say that we were still in this middle ground. That's effectively the order she made, is that we're not there. We're past that, and that's why I think there was a legal error, because she was citing the guardianship almost as a policy argument rather than going based on the facts.
Thank you, Counsel.
Does that help?
Time is up.
Okay. I'm out of time.
Thank you very much. Counsel.
Thank you.
May it please the court, my name is Stephen Zopp. I represent the appellee Alexandra D., the mother in the case. My colleague, Ms. Heller, will be discussing how the best interest finding and how the Title 14 guardianship should be factored into the best interest finding.
What do we make about your client not appearing?
Well, Your Honor, the law, I think, is pretty clear on if a parent doesn't appear at the hearings, that the court still has to go through the full analysis to make a finding to terminate a parent's rights. And I think that just because she's not there doesn't mean that the court should be able to go forward and terminate her rights in her absence.
So would you reject the notion that we have some law saying a parent who fails to show has admitted the allegations as set forth in the petition?
There is some law as to that, Your Honor, yes.
Mm-hmm. So how do we sort of put those two things together in this case?
Well, because as the petition was stated, when you draft a petition, there are grounds. Mm-hmm. Here are the grounds, as I understood them, against my client were abandonment and neglect. What you have to do is, from my understanding of the law, you still have to put forth a basis to support those grounds. The evidence and testimony still has to support a court's finding And I think it's the Tricia A. case, if I'm remembering correctly, from the Supreme Court that said this is it was under the old juvenile rules of procedure, but the rules are substantially the same. And I think the law of due process would be the same, as when a parent fails to appear, here's what needs to be put on the record in order for a court to make a finding of that.
But when we're in a case like this where there was some evidence put into the record about mother's sort of failure to engage over a long period of time and intent to permanently live in a different state from the children, and there was no affirmative evidence on behalf of the parent that counters either allegations related to substance abuse and allegations related to abandonment, isn't the court then doing that job that you have described to look at what's in front of it? I guess let me know how we handle that.
Correct. And then I direct the court to the record, which I do agree that the court's findings maybe didn't incorporate the complete record as it was stated. However, it's my understanding, and our new case that came down just recently, this Breonna J. case from the Supreme Court about the standard of review, I didn't see anything in there that took away from the fact that the court can draw reasonable inferences from the evidence. And so my argument is, when the court looked at the evidence that was presented, and to get to your point, there were things in the record that, despite my client not being there, showed quite a bit on her behalf. And I make this argument in my brief. I think it's compelling that, and this goes to the Michael J. reasonings for abandonment. What does a parent do? They have to look at the circumstances and the context of the parent. Michael J., that parent was incarcerated. That's a little different than my client, but she was at a treatment center in Florida. That's undisputed for, I believe, 2 separate periods of time. And
is there anything in the record that tells us what those periods of time were?
Your Honor, I believe it is in my brief, and I want to say it was April of around the spring of 21 and the summer of 22.
Okay.
And I think it was for a couple of months, if I'm correct.
And is that is that outside the hearing date?
That's before the hearing date, correct, yes. So she was, I think the record reflects, she visited the children around Christmas at grandmother's home, meaning that she was, as I understand it, in the state and at least had visited with the children. And then the severance trial takes place, I believe, in January. So she's in the state. But going back to your point, which is, you have to look at the entire record, which includes not only her agreement and consent to the guardianship, which you have to agree from a practical standpoint, despite the fact she has a substance abuse problem, she actually did something. And that's important, she took a step to make sure her kids' needs were met. And that's what a Title 14 guardianship says under the statute, that 14-1504. What is a parent doing? They're giving the powers and responsibilities to another person.
But how long can that be an argument against abandonment? Because certainly in this case, the guardianship, the formal guardianship is a fairly short time, but is that sort of an in perpetuity as long as the parent has done this up front?
So what I was going to argue here today was not that the Title 14 argument, or the Title 14 guardianship should completely preclude a petitioner on an abandonment ground. I don't think the law supports, I do have that in my briefing, but I think the alternate argument I make, which is the court needs to use the guardianship as one factor in the abandonment ground. So going to your point, which is, what else did this parent do? So there's information in the record that not only did she do the guardianship, and it was for a good reason, that she knew her kids, that she had contact with them previous to the severance, and the guardianship as well, that she did have those visitations. So there's other factors, and more importantly too, she was not wanting to revoke the guardianship, or there was no talk about, well, I need to see my kids, or I'm going to revoke the guardianship, or things like that. And even the grandmother admitted in her testimony that my client had no intention of revoking the guardianship.
The trial court also found that the mother moved to Florida in April 2021 with the intent to permanently reside in Florida. What does the record show about that specifically? Was there an intent to send for the kids after she settled in Florida, or to leave the kids behind?
From what I can tell in the record, she had gone to Florida for treatment at a substance abuse facility in April 2021. Came back, I think, in May of 2021. It didn't take, so I can see that's not good. My client saw treatment, it didn't work, but then she went back again. in August, but came back in the fall of 2022. So I don't think there was any, from what I can tell on the record, there was no intention for her to permanently live there in Florida. Her intention was always to come back, and then she had contact with her kids when she came back. So I don't think.
Are you saying we draw that as an inference from her back and forth, despite the testimony that she intended to permanently remain in Florida? Because it looks like that's sort of either a factual conflict, but only if we draw certain inferences from other facts.
Correct. And as counsel correctly pointed out, unfortunately, we didn't have her testimony there on that to find out exactly what her intention was.
Sorry, Judge Kiley, I know you had a...
But and going back to my point about how the court should factor it in. So, like, say for instance, there is a parent who, and the court brought up time too. How long has the guardianship been going on? What's the parent's intent? But if a parent just signs the guardianship, right, and then they're gone, they don't see the kids, or they had barely any relationship with the kids. They don't see the kids. We don't know why they signed the guardianship, and they're just gone. Okay. I'm here to concede a court should consider that and should consider that in the abandonment ground. But I do think my point is that the court should consider the Title 14 guardianship, decide what weight to give it, how much weight to give it, what the circumstances were around it. And I thought the court, in the record, the court's asking the petitioner a fair amount of questions. When did the mother last see the kids? Those type of things. And so I think that's exactly what the court was engaged in during the hearing, was trying to get to the bottom of exactly what the purpose of the guardianship was, how long it had been going on, whether mother or father had any intent to withdraw it at any point. And I think my argument is supported in the law. I would say that Michael J. and Timothy B., when you look at the circumstances of, giving a parent a chance, whether they're in prison under Michael J., of how to have contact with their children under those circumstances, or in Timothy B., where they're considering, what are the other options? They're talking about a normal home in that case, depriving the child of a normal home, which is different than a normal parent-child relationship. I agree that the severance, or the abandonment statute is very clear and written it's a rigid statute, fair parent provided support, contact supervision, minimal efforts. But I would say that's ARS 8531. But then the Supreme Court in Michael J. and the other case that it cites, it's that Pima County case, severance action S114487. It talks about how you have to, what constitutes support, contact, supervision. It varies from case to case and allows that, leeway of a court to make those decisions. And that's what I think we're asking the court to do, which is to have the juvenile court consider that and its analysis. And that allows for a lot of leeway within the court to either think, okay, this should be given a lot of weight because of the facts, or I'm not going to give it any weight at all and go forward with a termination on abandonment ground. I think I'm going to yield the rest of my time now to my colleague. Thank you for our time. Thank you.
Good morning. May it please the court, my name is Jamie Heller, and I work with the Maricopa County Office of the Legal Defender, and our office represents the father in this case, Logan R. Today I'm going to be arguing about the best interest issue, and because the parents have similar arguments, I was going to argue on behalf of mother as well. So the parents are asking this court today to affirm the juvenile court's order denying grandmother's severance petition on the best interest issue because reasonable evidence and inferences supported that best interest issue. As our briefs indicated, this court uses a deferential standard of review and doesn't reweigh the evidence or reassess the credibility of witnesses in this case. And
Counsel, when we're dealing with a guardianship, how, assuming that the guardianship is well done by the guardian, how do the best interest ever advocate blowing up the guardianship?
So if I understand the question correctly, in this case it was a Title 14 guardianship, and the Title 14 guardianship can be revoked based on one parent revoking their consent. And in this case, the juvenile court did find concerns with the way that the Title 14 guardianship was created in this case, and that was that the grandmother alleged a John Doe in the guardianship, didn't even allege Logan R. as even a potential father, and she did that in December of 2019. That's when the guardianship petition was filed. At the same time, the month after, she established paternity regarding Logan R. in January of 2022, but didn't notify the court then, who granted the guardianship, of paternity, and that paternity had been established. And I think this was one of the factors that the juvenile court did focus on in the best interest analysis, and the parties all agreed to allow the juvenile court to take jurisdiction of that guardianship to remedy this issue of paternity. And the juvenile court's factual findings focused on the fact that Logan R. testified at trial, he appeared, he testified he was appreciative of grandmother's care she'd given to the children, and testified that he had no plans on revoking the guardianship, had no plans on revoking it once he was released. And grandmother testified that she didn't believe mother, she had no indication from mother, who had seen the children 4 times since she returned to Arizona in August of 2022. Mother did not give her any intention of revoking the guardianship. And so I think the juvenile court in the ruling really used this and weighed it heavily, found father's testimony credible, found grandmother's testimony credible regarding neither parent's intent to revoke this guardianship, and found that grandmother also testified, one of the factual findings was that she had been providing the children with a safe and stable home, and that presently, at the time the court issued this ruling, the children's needs were being met, they were stable, and that there was no imminent threat of this guardianship being revoked.
So, I take it you didn't mean that it's a permanent situation, that at no point could the guardianship become inadequate.
The way in which the court analyzed this, at this point in time, when the severance was denied, the juvenile court found that the guardianship was not at risk of being revoked. I'm not arguing, and I would concede, that if mom today or dad today chose to revoke the guardianship, it would have to be revoked. The In re McCroot case makes clear that if either parent revokes their consent to the guardianship would have to be revoked. But that wasn't the circumstances, that wasn't the testimony that was provided, and the juvenile court was in the best position to judge the credibility of the witnesses and weigh the evidence, and her findings were that the guardianship was not at risk of being revoked. That could be an issue in the future, but at this point,
in terms of
speculation.
Best interest analysis, and this is something I think Judge Howe kind of raised earlier with your colleague, this is sort of an awkward case to apply, the Alma S framework, if we pull out sort of the quotes from a lot of cases on how you analyze the detriment versus benefit present. But there is one consistent thread, and that's permanency and adoptability as benefits. How do we take into account sort of the robust case law telling us that that's a significant element of our best interest analysis in a case like this where the permanency and adoptability weighs in favor of termination because the current situation is admittedly not permanent? How do we take that into account? Is there a good case that talks to us about guardianship and best interest, or particularly Title 14 guardianship and best interest?
So I'm sorry for interrupting. Yeah. I'm not aware of any case to point you to. I didn't, put any in my brief regarding that. The In re McCroot case is the one about the Title 14 guardianship and consent. I'm not familiar with other cases that address the Title 14 guardianship and how to analyze it. I would just point the court to that, the juvenile court is the one that gets to ask, hear what evidence is being presented. And when it comes to best interest, the juvenile court doesn't have to grant termination just because a child is adoptable. I also want to point out to the court that in this case, under the facts and the ruling, these children were not adoptable because the juvenile court did not find a substantive severance ground against mom. Okay? So because in order to terminate parental rights, case law makes clear you have to have a substantive severance ground and best interest. In this case, the juvenile court did not find any substantive grounds against mom. So when it got to the best interest analysis, these children weren't adoptable. Grandma cannot adopt the children if mom's rights are still intact. So I think although the juvenile court's ruling didn't say that, that's our law, and it's clear that at the time the court issued its ruling, these children weren't adoptable because mom's rights couldn't have been terminated.
Is it your view that if there's a guardianship in place and the kids are doing well, that defeats any best interest finding?
I wouldn't say always. I would say it based on the specific circumstances of the case and the facts and the juvenile court's assessment of the credibility of witnesses and the evidence that's presented. I think it really depends. These cases are very fact-specific, and they're based on evidence that's presented and circumstances presented at the time. In this case, the juvenile court focused on specific facts with regard to best interest. It did focus on that guardianship, but it focused on Grandma's testimony, that she'd been providing these kids with a safe, stable home, and she was going to continue to do so.
So she's actually working in taking good care of the children. She's working against the idea of permanency.
I believe our understanding of the ruling is that the court believes that in this case, grandmother was providing these children with safety and stability, which usually is what's used in finding permanency, say in a case where you have DCS involved, where the kids are in foster care. That's a different circumstance because when a child is in foster care, they have to go to the juvenile court every 6 months or every 3 months for report and review hearings and all that. In this specific case, the state's not involved. It's a relative, a grandparent, who's caring for these children, providing them safety and
we shouldn't have a double standard. I think that's a fair point that your colleague made, that in termination cases, we apply the law. We don't provide a double standard depending on who is the petitioner. And it is the case, I think, as you have acknowledged, that this was not a permanent situation. In fact, definitionally, it's not permanent. Either parent, under any circumstances, at any point, could revoke the guardianship. So I guess that's what I would like to get at, is how do we weigh that clear lack of permanency and Judge Howe's point that the better grandmother did, the more she sort of was acting against her own interest in providing permanency for these children. That seems to be the upshot, although clearly not the intent of the juvenile court's ruling. So what are we to do with that?
I would answer that as permanency is just one of the factors. The law makes clear that the juvenile court is supposed to take into consideration the totality of circumstances at the time of best interest. Case law has described that as assessing whether or not children are adoptable and also parents' rehabilitation. And if you take those two factors in this case, based on the court not finding a substantive ground against mom, at the time it issued the ruling, the children were not adoptable, and the record does demonstrate the rehabilitation efforts on the part of my client, exhibits regarding services he did while he was incarcerated. He was enrolled in a 100-hour counseling program that he entered into of August of 2022 after he had his relapse, which is in the record on marijuana, and he was almost completed with that, 96 hours. And so I think there's reasonable evidence in this record to support the juvenile court's ruling, and based on the deferential standard of review, we would ask this court to please affirm the juvenile court's order.
Counsel, we appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.